I'll be doing something else and somewhere. But I don't want to open room for speculation.
No. That's okay. And you've used such a low term.
Yes.
You don't want to open room for speculation.
Yes.
Which is interesting because actually I think something that came to my mind was, how is a lawyer's CV? Do you go via cases? And this is just it's almost like a silly question, but you know, considering I'm someone from outside.
Yes. One thing I just want maybe to tell anybody watching and who want to be an advocate that yes, law is a very good career. It's a good career because the other time I was doing my CV, because I was requested to be a board member of a certain organization, and then they told me I do a CV. Going back to my emails, I saw that the last time I prepared my CV was in the year 2016. Because in 2017 I opened my law firm. I didn't never look for any kind of employment. So one thing is, an advocate, you in terms of building your CV, the fact that you are an advocate of the High Court and also the years of experience, that is CV by itself. Because today, maybe by 2022 I've practiced for 6 years, and maybe by next year it continues. An advocate of 10 years experience is expected to know very much than an advocate of 2 years experience. But basically, this profession of ours, as I had told you earlier, that if you have handled a case, if it is a criminal case, from plea taking or from the arresting of the suspect to till judgment, you will have much experience in terms of that line of the law. If you have handled a civil matter, for example, an ELC matter pertaining fraud and cancellation of a title deed, you will be an expert in that. So as a lawyer, the CV of a lawyer is always ongoing. But sometimes someone can ask you, which matters have you handled in relation to environment, in relation to land? Because
community
yes, you can tell them, because things are in the public domain. I handle this matter, it is in the public domain, it is in Kenya law reports. So that is the CV of a lawyer. But I think the most important thing, because the most important thing is, one, the integrity of the advocate and how passionate is he to this case particularly. Yes, because I remember someone told me that the best lawyer is the lawyer who knows where to find the law. Basically, if it is this matter, I know it is this act of parliament, it is this article of the constitution that is in relation to this particular case or this matter. That is the best act. Yes.
That's interesting. At the moment we have, for example, Form 4 leavers in their houses, and maybe there's one who's always wanted to consider law, or one who's always put law as a second option. What advice would you give to them?
One, I would advise maybe students who want to pursue law, and I would also advise their parents. First, I still say law is a calling.
Yes.
It is a calling, because if you have the passion of doing law, do it. If that passion is on your parent, it is the parent who has the passion, don't do it. Because basically you will be disappointed, because along the way, if you don't have the interest, the inherent interest to do this thing, to undertake law, then it will be like you have been pushed, maybe by the parent or something. So personally, I had no option 2 in terms of career choices. My first option was law, the second law, the third was law. So basically,
personal.
Yes, because this thing, as I told you, I built it from primary school that I wanted to be a lawyer. So if this student is passionate about doing law, they need to do it, because they will still make it, because you have this engine inside you that is pushing you to do this career. But if it is the choice of the parent, and I would also tell the parent, if it is the choice of the parent, that child will go to law school. They will not finish school, or they will go to Kenya School of Law again. But because it is a journey of 4 years in LLB, 2 years in the Kenya School of Law, this is a journey of 6 years. This journey, along the way, so many things happen even in a year, let alone 6 years. So if this child has no interest of doing this thing, that child will drop, and then you start fighting with this child. The other advice would be, if you want this child to be a lawyer, from the tender age, start modeling this child or advising this child to like law, to just bring out this passion out of it or her. Then if they are passionate, I am telling you that child will do law, will finish, and will fully succeed in the career. Yes.
That's interesting. As we wind down, is there any last 2 cents to tell people? Because we've addressed from 4 levers, but then as a general, because here's the thing, you're an advocate with an interest in community. Is there any, for example, note downs or any advice to the youths that you'd like to tell them?
First, I would advise the youth and tell them to remain or become focused, because it is so much admirable to see everyone succeed. It is not admirable to see yourself as the only successful person amongst your peers. So the difference is focusness. Some of the youth have lost focus, and then they just become comfortable with the small they have, or wherever they are. Wherever they are, they become comfortable. You put yourself to a comfort zone. Maybe at your village, for example, you are the most successful youth. So you are comfortable because you have lived to the village standards or to the village setup. The world is global, and we are competing, and not even competing. We are, if you are to succeed, compare yourself amongst people in the globe. So you don't just go there, become comfortable because you are successful in your village. No, I think it is the whole world, and also on probably challenges we have also passed through with clients. Sometimes a client comes to your office, the client has a weak case, completely weak.
What's completely weak? Is there
in terms
of loss?
Yes, one, a client can come to you as an advocate. The client comes and the client doesn't have the facts to support their case. And out of scarcity of knowledge with the client, they think their case is straightforward, and they say, no, this case is quite straightforward. There is nothing like a straightforward case, because it is straightforward in your eyes, in your mind, and in your heart,
but not from a legal perspective.
And not from a legal perspective. One, there are facts. There is also procedure. So these two things, as an advocate, if you don't have the facts, then you challenge the procedure. And your case can be challenged on procedure, maybe by raising a preliminary objection. That is a point of law that, okay, you may be having the right
Yeah.
But there is this law and this one. This section of the law that you violated. For example, you may be having a right, but you have slept on your right. And there is what we call limitation of actions, which is an act of parliament. You have your right, but this part, this you didn't play your part, or you didn't follow your right within the specific, the statutory provided timelines. So in that regard, yes, you have a right.
Yeah.
You slept on your right, but you will not get it because you slept. You understand?
Yeah. But the question I'm asking is because this would mean more of a lack of knowledge to act on some of the rights that I was meant to go through with. But I mean, how do you let people know that? Because I think people will get to understand that this is a problem right when you get from a legal perspective. But in terms of general knowledge, it might not, it might not be known.
Yes. What I normally tell my clients is that whenever you get a court document, not even, or whenever you get a letter from an advocate, or from the administration, through maybe the DCC, the county commissioner, the police, always go and get advice from an advocate.
Okay.
Get proper legal advice on what you are supposed to do. Because out of that knowledge, you may, for example, assume it.
Yeah.
People outside there get court documents. Your name appears. You see it as a stamp of the court. These are court pleadings.
Yeah.
Then you don't go to look for an advocate to get legal advice on what you're supposed to do. What happens is this person proceeds with the case. An affidavit of service is filed that we did serve him or her with the court documents on this particular day, but you chose to assume judgment will be entered against you. You understand? And when judgment is entered against you and there was proof of service, it is even hard for you to come and set aside the judgment.
Do you think people evade getting legal advice because they assume it's expensive, or is it because of a fear of, if I go this direction, it's going to get serious and I don't intend it to be serious?
One, I think if someone assumes that if he goes or she goes to court to defend a matter in which she or he has been sued, that it will be serious. It is more serious if you ignore and then judgment is entered against you than when you go to an advocate. Seek legal advice. Maybe if you don't have the money, to, for example, hire that advocate, that advocate can help you and advise you what you are supposed to do. The advocate may even initiate negotiation with the other party and you settle it out of court.
Have a settlement.
Yes, I think the perception that people have is this case of mine will take 2 years. This case will take 3 years. This case will take 5 years. But never assume any kind of a document, legal document, serious document, served upon you, and then you just go back and sit. Yes.
That's interesting because I'm sure a lot of people have gone into that trap where there's somewhere you needed legal advice, but you assumed it, and then people are paying the consequences.
Yes, people are paying the consequences, and mostly in civil cases. Maybe if you assume judgment is entered against you, for example, and then after judgment, cost. You're supposed to pay cost for the suit. Then the advocate prepares the bill of cost. Then this advocate comes and attach your property. What happens if you are not able to pay the cost of the suit? Civil jail. You go in for 6 months. So people are paying consequences. People assume, then it is at that time when they are being attached, when they are being sentenced to civil jail, is when they come and say, oh, you know what, I wasn't served with this document. But you were served. There is an affidavit of service. So for you to be safe, watching outside there. If you are served with any serious document, court document, letter from an advocate, letter from the police, letter from the administration, it is good to seek legal advice. It is your right.
I think there's something else that's come to my head. The issue of land. People acquiring land, and I think, because here's the thing, we've all seen cases where someone thought they had a title deed of a particular place, but then there's a duplicate, and the duplicate might be the other one is from the original owner, but then you're given a duplicate. How will you let people know how to go about these things? Is there like an MOU you sign with the people who sold to you? Is there like an agreement with legal? Is there, from a legal front, what advice would you give people?
Yes, one, land transaction, the law provides that every business contract for sale, land dealing should be in writing. I cannot sell you my land by verbal. By word of mouth. The same must be in writing. The law says that because land is a very emotive issue. Land will remain there even when both parties, the purchaser and the vendor, dies. I tell my clients and my friends, land, whenever you're doing a transaction for land, you must appear before an advocate and put it in writing. And if possible, each and every clause should be in that agreement. Because sometimes clients come and say, we have agreed on this and this and this. But these other ones, we had just agreed. That one have a small AUA candle. And I don't think it's supposed to be candle. Everything should be written. Because this land you're buying, you may die as the purchaser, you may die as the vendor, the purchaser still has your balance, but if it is not in the agreement, how will your children get that money? You won't. When you go to court, whenever a dispute arises and then you go to court, and you have this agreement in writing, you will prevail, because this agreement for the parties will prevail. Because what the court normally says, they say, we cannot write an agreement for the parties. We will just interpret what you wrote. However oppressive it was to you, but you did sign it. Yes. So the courts will not construct or try to rearrange the agreement for the parties. No. The court will just interpret what you people sign. So you need to be very keen in this agreement you are doing. So issues of land, people are supposed to be to follow the law. Yes, because eventually you may pass on, and then you didn't process a title deed, and then your children will not get that land. They will not get it. On the issue of double titles or two titles outside there for a particular piece of land, that is fraudulent. That is pure fraud, because when a title deed is outside there, when a title deed is outside there and it has been issued by the land registrar, then the government will indemnify you, because they are the ones who issued you with this title. If they issue another title to another person, there is a procedure of cancelling a title deed. There is a procedure of cancelling a title. You file a suit in court. So if you did get a title deed, and then I went and processed another title deed, then your title deed is the one that is legally right. I can file a suit in court, challenge that you are not supposed to be issued this title deed because of A, B, and C. Those are my grounds. The court will eventually determine, because I will serve you with the pleadings, with the suit I filed against you. You will also put in a response and prove your title deed was legit. But I agree, sometimes these things happen. And it is people in the land registry who will probably advise someone or process a title deed. No, completely. If there is another title deed there, they can recall the title deed, but you as the complainant,
The prospect,
yes, file a suit in court so that this title deed is cancelled. Yes, through a legal process. Yes.
That's interesting. I think, because I'm sure a lot. And here's the thing with the young people coming out, some actually earning their own money. I'm sure land is the first thing they think about investors. And maybe they know, maybe they don't. And you see, they fall into such kind of traps, and it can be really annoying for someone who's starting out. But thank you, Sana, Mr. Parseen.
Yes.
It's been a lovely session, and to our viewers, welcome again. Thank you for watching. This is VON Online Chats, where we do informative, educative, and inspiring stories of the people of Narok, the voices of Narok. Thank you. Karibuni tena.
Thank you so much.
Thank you.
Happy.
Yeah.
Thank you so much. I really appreciate it.
It's been lovely.
Yes, thank you so much.